So just to put it in layman's terms, to go through it one more time. So am I right in thinking that like a applicant, not always, but most of the time, would be expected to comprehend a piece of law and then understand when it will be acted on, how they'll have a set of facts, and then they'll see whether the law will be acted on these facts.
Yeah, whether it would apply to those facts. Yeah, absolutely. And then, that would be the beginning of the interview, really. Okay. And then we'd start tweaking the facts and changing them, inviting candidates to think about whether they...
Hello everyone, welcome to Cambridge from the Inside. We have a new guest today. Would you like to introduce yourself?
Yeah, hi Siam. Do I speak to camera or do I speak to you?
Me.
Okay. So my name is Rachel, as you know. I'm a fellow in law here at Trinity Hall. I've been at Trinity Hall for about 6 or 7 years now. I try to lose count. And I teach criminal law and criminal procedure and evidence to students both at Trinity Hall and at other colleges.
So today we're going to be talking about law admissions advice. I think that we're going to be specifically talking about the perspective of a student who's decided that they're going to apply for law, have probably submitted their UCAS application, and therefore we're going to be talking about the LNAT, the admissions test, and the interviews, the law interviews.
Yes, that's right. Though on the timing of the LNAT, that might need to be a little bit earlier than the submission of the UCAS applications, but we're definitely going to talk about the LNAT today.
Nice. So starting with interviews, I think this podcast, by the time that will come out, people would have found out whether they've had an interview or not, or most people would have, and students are stressed and they're trying to prepare for them. Yeah. So I was wondering, what general advice do you have for students for their Cambridge interviews?
Yeah, good. I'm so pleased that we get to do this interview because I want to help. Yeah. So what's my general advice? Breathe.
Yeah.
Listen, think, and share. Okay. So nice. Breathing. We know that candidates, when I say come to interview, it's sort of, it's hard to move away from that kind of language, but when they come onto Zoom, when they appear on Zoom or whatever platform we're using for the remote interviews, we know that candidates find the process nerve-wracking. That's normal, I think, some degree of nerves and anxiety when you really care about something and you're in an unfamiliar environment, I think is par for the course. But we expect that, and we try, I think my colleagues in law and I, to put candidates at ease. We're very used to looking past some of those signs of nerves to see the quality of the answers that are underneath. So if you do feel nervous, just take a few deep breaths, try not to panic, and remember that it's okay to be nervous. We expect it to some degree. And it's not unusual, I think, for interviews to sometimes get off to a shaky start, right? So I think sometimes candidates, I say sometimes candidates because this is exactly what happened to me in my first undergraduate interview at another university, which I won't name because why would one apply there? I'm joking. But I remember my first interview, and I was given an exercise to read and asked a question about how a particular rule would apply to a set of facts. And I answered the question, and the minute I finished the sentence, I just thought, and I sort of looked at the interviewer, and the interviewer sort of looked at me, and I can't really remember what he said, but he sort of said something like, well, what about this? And I was just like, yep. Well, I'm in my head, I'm thinking, yeah, that's a really good point. What I just said was all kinds of incorrect. And he said, do you want to think about that again? And I said, yeah, okay. So, and I think, remembering back, I probably said something along the lines of, well, based on what you've just said, I think actually what I missed before was this, and what we should do now is that. And the interview carried on. And I remember thinking about that and being really worried. Like, I think I messed up the very first part of this interview. Is that a really bad thing? And actually it wasn't. It was fine. Clearly it was fine. I got a place, and here I am now, however many years later. But I think there's an important lesson in that, right? Because if you allow an interaction like that, whether it's at the beginning of the interview or in the middle of the interview, to throw you off for the whole sort of 25 minutes, half an hour, then there's a real lost opportunity. Because for me, as an interviewer now, a good interview, a really good interview, doesn't require perfection, doesn't require a candidate never to say something that maybe isn't the best argument they could have possibly put forward. I might disagree with them. I might think that they've missed something. But what matters is what happens next, and how you take the kind of feedback that the interviewer is going to give you. So and work with it to make progress. Because interviews really are about going from A to B, and what happens in the middle of that process. So, the first part of dealing with that kind of challenge is to take a breath, to expect to be challenged in that environment, and to see that as an opportunity, rather than something to be sort of inherently fearful of. So, don't expect to get everything right, and take a big deep breath.
Nice.
Listening is also really important, right? Because if you spend the whole interview just thinking about the last thing you've said and looking back at whatever notes that you've taken in the pre-interview prep time, and I know we're going to come on to talk about that, then you'll be missing important cues from your interviewers. It's really important that candidates listen to us, to the information that we're giving them, to the new scenarios we might be posing to them. Interviewers are going to invite candidates to think about the material under discussion from a new perspective, or to challenge that initial idea. We might ask students to reflect on whether the argument that they're developing is a strong argument, or where the weaknesses in that argument might lie, how that argument can be strengthened, what distinctions they might want to draw between different types of cases or different types of scenarios. And I think if students aren't paying quite close attention to what we're saying, then a lot can get lost in that interaction, and that's where I think sometimes students struggle to show their reasoning skills at their highest. So what do you do with that, right? How do you listen well? Well, I think being confident, or even if you don't feel confident, pretending that you're confident, and asking us to clarify. If I say something to a student and in an interview and they haven't quite heard what I've said, maybe there's been a technical glitch, or perhaps I've just framed the question in a way that they struggle to pass, to understand, it's absolutely fine for a candidate to say, could you clarify that? When you used infer, I've not come across that word before. I don't know what that word means. Can you explain it? It's that's absolutely fine, and is actually really helpful for us as interviewers, because if a student is struggling or a candidate is struggling to engage with the question that we've asked because they've misunderstood or misheard us, or don't understand some of the language or the vocabulary that we've used, we're going to be able to help that student make progress in the interview more quickly. If we understand that, we see that, and we can adjust for it.
Nice, because I imagine those, like, the ability to kind of like say like, oh, like I didn't understand that specific word. That kind of like honesty shows that those specific students will be good students to teach. Because you kind of need that kind of honesty in the supervisions. Whereas, as I imagine, as a supervisor, if the students are just completely silent, you have no idea whether they understand or not.
And often, as a supervisor, what's important to me is understanding why students don't understand something. Often, I've been saying this on repeat to my first year students all term. Sometimes if you don't understand something as a law student, that's not because you've done anything wrong or you've missed something or you're confused. It might just be because the law is confusing. So when a student can come into a supervision and explain in detail what was confusing, why they found it confusing, what they don't understand, we can then begin to sort of see and unpick and uncover the inconsistencies and incoherence in the case law. Equally, they might be confused because there is a concept that they haven't understood particularly clearly, or because certain language or vocabulary is sort of technical or specialist. And I think that's a really important skill for students as they're developing, to sort of not run away from that, to try and hide from it, but to embrace that uncertainty as an opportunity to learn. And what I hope and what I encourage our students to do is, if they're reading an article or a case and there's language that seems to be quite important to unlock the meaning of the argument or the scope of the authority provided by a particular appellate case, I want them to sort of to try and figure that out, right? Google it, you know. And you can't do that obviously in an interview setting, but you can use us. You can use us for that, right? You ask your interviewer, you know, don't suddenly start Googling stuff when you're in the interview, but use us for that, right? Oh, I'm not sure what you mean by this. And actually, for me, if I can see that a candidate realizes that the meaning of this word is fundamental to unlocking the meaning of this paragraph, or understanding the test, or really grappling with the challenge to their argument that the interviewer has posed, in a sense, the fact that they don't understand what that word means is neither here nor there, because I can give them that explanation and we can carry on. What's really helpful for me in that scenario is to see, you've seen that this word matters, and that kind of close attention to textual reasoning is a close attention to detail, close attention to texts. That lies at the heart of legal reasoning.
Because it's quite strangely, by asking the question, you're showing how much you do know.
Exactly.
Because you're showing them that you've asked this specific question.
Nice. I think that's right. And I suppose this, this I think leads me on to the importance of really thinking carefully. I mean, it sounds obvious, right? You're in an interview, you should think, but often I think when we're under stress, the ability to engage with our
you feel like you need to
cognitive
rush.
Capacities, you can sometimes feel that rush. Once you've taken a breath, you've listened, you've clarified, it's okay to take a beat. We don't, there's no points for sort of answering within a nanosecond of me finishing my sentence, reflect on what you want to say. That will allow you to answer the questions in a sort of concise and more controlled way. I mean, that's a skill and it takes practice. So, good interview prep will definitely involve talking to other people about, interesting and difficult things, answering questions. It doesn't have to be questions about anything remotely connected to law. It could be, do you, I don't know, something that you've read in the news or whatever, right? What do you think of the current, the most recent budget or something like that, But just get used to answering questions orally in a way which is concise and controlled. Again, that's not going to be perfect. We don't expect students to do this brilliantly, but it is a skill that we're sort of evaluating in the interview. So thinking is the prerequisite to that. So you hear the question, you understand the question, you clarify anything you don't understand within the question, consider your answer, and don't, sometimes I worry that candidates think that the goal of an interview is to defend the first argument they've made at all costs. And that's never the objective. We want you to consider whether the arguments you've made are strong or whether you can see weaknesses or flaws in those arguments. And sometimes we might move the goalposts a little bit to get you to think about the issue from another angle, or identify weaknesses that we wouldn't have expected you to see before we'd given you a scenario or a situation which might might offer up some new information for you. So genuinely reflect on that. Consider whether this new information should change your view. And if it does, try and explain why. And then I think we get to the sharing of the ideas, and that's so important, that a one-word answer is rarely helpful in an interview. What are the reasons for maintaining your initial position? What's persuaded you that it's actually, you need to rethink or take another approach? If you're very confident in your view, explain why you're very confident that's the right approach to take. If you're not sure, again, tell us why you're not sure, because like you were saying earlier, that the fact that you're not sure might actually show something really insightful. There is very rarely an obviously right answer to the questions that we ask in interview. And an appreciation of why an issue or an argument might be finely balanced is often a lot more impressive than a desire to oversimplify something that is clearly very, very complicated. Very few things in the study of law are straightforward. Very few questions disclose only one possible answer. So that kind of flexibility and curiosity is really helpful to see in an interview. And then the last thing I would say is just that the interviews are designed to be challenging. They're not supposed to be straightforward. And let's say hypothetically a student comes in, we ask a couple of questions at the beginning of the interview, and in the back of my mind I'm thinking, wow, that's the best answer I could possibly imagine anybody giving. We're not going to end the interview there, because I don't learn very much about an applicant if I don't see how they cope with being stretched, because that's really, in a way, what we're testing, how well someone can get from A to B to C to D, and how they reason along the way. So, the people who are interviewing you are smart people and they've been doing it a long time, right? So that we're going to find a curveball, and we're going to throw you a curveball, because what we're testing is how you cope with that. So, that's where the breathing and the thinking and the listening and the sharing comes in. But try and enjoy that challenge along the way. If you come out of a law interview and you think, gosh, that was tough, that's not a sign that it's gone wrong. That's our hope and expectation, that there'll be a challenge for candidates to meet, and the candidates who do best in the interviews are the ones who meet that challenge. And I hope that the candidates enjoy it, because I think if you go into a law interview and you enjoy the challenge, that's a really good sign. Because that's probably a good indication that you'll enjoy the kind of teaching environment you'll hopefully find yourself in. Not too far away in the future.
Because the interviews are, for most subjects, if not all of them, emulate what the supervisions are going to be like.
Yeah, exactly.
Nice. So more specifically with law, wanted to hear more from you about what the law interviews are like. I know that they're different between each of the colleges and each college. I mean, there's probably a huge similarity, but they have autonomy of how they do their interviews. But at least in Trinity Hall, what can a student expect in a law interview?
Yeah, I think it's that point that practice differs from college to college is so important. It strikes me that the advice that students will see on the university website or on sort of third-party websites, some of which is terrible advice, but some of it's good. There is good advice out there. It's great advice. What Cambridge, the sort of university websites, put out is all very good advice, but it's not all applicable, or it's not all a good indication of exactly what you're going to see at Trinity Hall, because it's broad. It's trying to capture that variation in practice. And when practice varies, some of it's going to be relevant, some of it's not so much. So I guess what do we do at Trinity Hall? Well, I never ask the settler questions, right? If you come into an interview with me, I'm not going to sort of say, how's your day? Or, do you have any siblings? The interview I was telling you about before, the first question where I thought, oh God, I didn't really do a very good job of that answer. Actually, that was the second question. The first question I was asked was a settler question. Right. And I remember this vividly, and I'm very fond of the person who was interviewing me. He was a fantastic, supervisor, and a lovely and wonderful supportive person to the hundreds of students he taught. But I remember the sort of settler question, and I'm from the northeast of England, and I'd travelled down to the south, travelled down south on the train that day, or the day before, and I can't remember how it was phrased because it wasn't as precise and sort of interrogatory as this, but the content of the question was essentially, if I was travelling from Edinburgh on the train to Newcastle where you live, would I pass Lindisfarne, which is like All Holy Island? It's a sort of historic sort of tourist location, which is incidentally between Newcastle and Edinburgh. But I am really rubbish at geography, and I hadn't travelled around the northeast very much.
You probably weren't driving.
I wasn't driving. And I had like last been to this place when I was like 12. Yeah. And I had no idea. And I just had to guess. and I came out of the interview, and the first thing I did when I came out of the interview is I called a friend. And I said, and he said, how's the interview? And I said, where's Holy Island? Where is Lindisfarne? Please tell me it's north of Newcastle. He was like, what? Yeah. So I will never ask a candidate any kind of sort of settle you in, tell me about your life question.
It's a good example because from his perspective, he's thinking it's quite nice, a nice essay, but you never know how it's going to be taken.
Exactly. So the first thing you'll hear from me in an interview is, hello, thank you for joining us. Some introductions. I'll introduce myself, my colleague who because we always interview in pairs. So the other law fellow will introduce themselves. We will maybe do a little bit of checking that the tech's okay, or sort of giving students some guidance about what to do if there are technical problems. And then we will give the student a sort of indication, or the candidate, I should say, an indication as to what we're going to do in the interview, And so what do we do in the interviews? Well, I think for every single interview season I've ever done here at Trinity Hall, both interviews have involved specific exercises. They almost always both involve pre-reading. Not exclusively. In the pandemic, we didn't set pre-reading exercises, so I wouldn't want to be taken as giving any cast iron guarantee that we'll never again do an exercise without pre-reading. But it's much more common at Trinity Hall to set pre-reading and then interview on that exercise.
And is that reading that you do just before the interview?
Mm-hmm. Yeah, that's very important because we don't expect any prior understanding of law. You don't need to know anything about. I mean, it's helpful to kind of have a sense as to like what the law is as a general concept. But if you're applying for, I guess politics, you might not have studied politics at A level, but you should have a sense of what politics is. But beyond the sort of baseline level of, there's some reason you want to apply to do law, and you understand that it's, the law provides provides rules and guidance which helps adjudicate between conflict, resolve conflict between individuals, or create systems in which people are unable to do things. I mean, even that's like way more technical. I would never expect a student to say that to me in an interview, but that kind of,
Impressively managed to just give a very one-line definition of what law is.
Well, I mean, I could hear in the back of my head like, oh, all my colleagues say about that. What about this? But, we really don't expect any kind of understanding, like prior understanding of law to do well in the interview. You don't need to study A-level law. So what we will give students generally is maybe a fake statute, a fake piece of legislation, whether it's a criminal offence or something related to contract law or tort law or land law. And possibly we might give them a factual scenario in addition to read, or we might just give them the mock statute. And then with that kind of exercise, if there isn't a factual scenario on the page, then a factual scenario will be presented to the candidate in an interview. And what we're looking for is, has the student understood the statute, what it does, the effect of the provisions. By provision, I just mean sort of there'll be like number 1, section 1, and then maybe there'll be subsections A, B, C, or something like that. I should say subsections. Subsections will be numbered, and then paragraphs would be A, B, and C. But do they understand what the subsections or the individual paragraphs do? What effect they have? Are there tests contained within the statute? So, for example, criminal damage, for example, the actual criminal damage statute provides a definition of what constitutes criminal damage in English law. A person commits criminal damage when they intentionally or recklessly damage or destroy property belonging to another. So can they identify, in order to commit criminal damage, which components within this test are necessary? Are there alternative options at any stage? So intention or recklessness. You don't need to both intend and be recklessness. It's sufficient to either intend or be recklessness or be reckless. So it's comprehension, really.
Yeah, it sounds like
understanding what the text is doing, close attention to detail.
Could you explain for the viewers and for myself what statute and means and what you mean by test?
Yeah, good. So when Parliament makes law, they enact a statute. We would say that they enact a statute or a piece of legislation. So the Criminal Damage Act. It's embarrassing, isn't it? I can't just list statutes. What have I been teaching this week? The Offences Against the Person Act, the Police and Criminal Evidence Act. So you can, all of this legislation is available free online. So you could Google all of those pieces of legislation I've just cited and see it all as it was enacted, and if it's been later amended, you can see the more recent versions. And you can look at, if you want to go and look at Section 1 of the Criminal Damage Act now, you'll see that definition of criminal damage that I just gave. And some pieces of legislation are more complicated than others, of course. But that is the way in which Parliament makes law. So often we will give students either a real piece of legislation or a fake piece of legislation. And then we're looking at how well a student understands how that piece of legislation or that fake statute is structured, what it does, how to satisfy you asked me what's a test
as well.
Yeah, good.
That was good. We should go back onto that as well.
Yeah, well this leads me onto it, I think. If say the statute is concerned with what, let's say we've got a fictitious statute which is concerned with whether or not a contract is valid, right? There might be a test for validity, or it might be that the statute provides a number of concepts or factors that would invalidate a contract, and for each invalidating factor, or I should say vitiating factor, really, if I'm in the world of contract law, for each vitiating factor, there's a test to establish whether that particular vitiating factor is present on any set of facts. And so what we would want students to do is to look at that statutory language, the language used in the statute in detail, to try and figure out what is the minimum I would need to prove on any set of facts to determine that this vitiating factor is present, and therefore the contract can be unpicked.
So am I right in thinking that applicants might be expected to both look at how credible the legislation is in terms of how it's structured, like how good is it as a piece of law?
Well, so that's a separate question, and I think this distinction is really important, because when we're engaging in an interview around, say, a fictitious statute, often what we'll be asking students to do is apply that statute to a set of facts. And then the question is just, how does the statute work? What does it do? And can, now I know what the test is now because I've identified the test for.
I see. Okay.
The kind of deception that might vitiate a contract, kind of misrepresentation that might vitiate a contract, and I have a set of facts, and I need to figure out whether these set of facts sort of whether it matches, if you like, whether I can establish this kind of test, satisfy this kind of test on the facts. But the student might think that's stupid, right? That's a terrible test. That doesn't really feel like intuitively, that doesn't match my kind of pre-existing understanding of what deception is, or I feel like this gives me a really weird answer that just looks on its face wrong. The listening part's important here, right? Because if the interviewers asked you to apply the statute to the facts, you need to do that. And if you think, but that seems really surprising to me, share that. Yeah. Because in law, there are different kinds of skills that we deploy as part of our legal reasoning, and, application of the law as it stands to the facts is one test, and critical evaluation of the law is another. And the separation of the two is really fundamental to good legal scholarship and being a good student. And it's something that I've been reiterating to my first years week on week in supervisions. It's something that I'm trying to teach them. It's tricky, especially when the law's complicated, to pull those two things apart. But we'll definitely be looking for that in interview.
Yeah, because I guess there's like two like non-ideal situations where you're pulled more towards the critical evaluation, and that's stopping you from kind of applying it and doing it. And then on the other side, if you're doing it and applying the law, but you might get into the trap of never critically evaluating, does that actually make sense? Exactly.
And I think, the interviewers will have a sense of what we want to test in that interview, and the one interview isn't the whole part of the picture. So our aim is to use every aspect of the application process to together and holistically test the range of skills that we want. So it may be that someone goes through an interview and doesn't necessarily engage in very much critical evaluation of the law.
It's a short interview.
Because it's a short interview, and we might be focusing that year on other on other kinds of skills in that interview. But certainly it's fair game, if you like, for us to be asking, and what do you think about that? Do you think this is the right kind of outcome? Why not? Well, okay, if the law sort of works in this way, how would it then also apply to this kind of case? When we change the facts a little bit, would you get the same answer? Would you get a different answer? Okay, and what do you think about that? Does that make sense to you? Do you think that that's desirable or undesirable? And can you explain a little bit why you think it is or isn't desirable?
Nice. So just to put it in layman's terms, to go through it one more time. So am I right in thinking that like an applicant, not always, but most of the time, would be expected to comprehend a piece of law, and then understand when it will be acted on, how they'll have a set of facts, and then they'll see whether the law will be acted on these facts.
Yeah, whether it would apply to those facts. Yeah, absolutely. And then that would be the beginning of the interview, really. Okay. And then we'd start tweaking the facts and changing them, inviting candidates to think about whether the law as it's provided does draw certain kinds of distinctions. What kinds of distinctions does it draw between different kinds of cases? When are cases similar, such that the law would apply in the same way? Another word we would use for that is analogous, but so similar that you'd apply the law in the same way. Or when are they so different that the law ought to be applied in a different way? When would we distinguish between the two cases is another way of putting that point. And then we would, I think, often build to that kind of critical evaluation. How can you use your instincts and arguments about what you think we're trying to achieve here, what we should be trying to achieve here, the consequences of applying the law in one way versus another way, to form a view as to how best these potentially quite ambiguous provisions should be understood, or whether these provisions which aren't ambiguous are just wrong. Or I shouldn't say are just wrong, but what I mean is are undesirable and should be changed, and what might that change look like in order to better achieve those purposes.
So I believe, so is the second interview any different to like the structure of the one we've just been talking about?
It's very similar usually. And again, there's no guarantees that we're always going to do the same kind of structure every year, but we don't have a general interview. It's it's not going to be we're not going to ask you, why do you want to I certainly have never asked a candidate, why do you want to study law? I personally have never asked that question in an interview. I don't remember so far as I can recall. We want to see your enthusiasm and curiosity and interest in the subject, but there are other ways, I think, of identifying that on your application, and other things I want to be looking at looking for in an interview. So other exercises we might give if you've had a mock statute exercise in one interview. There are other kinds of exercises that we do. Something that again would involve pre-reading. So all the pre-reading is done sort of on the day of the interview, immediately before the interview for a set period of time, and then you come straight from that pre-reading into the interview. So we might give you an extract from a case from the Court of Appeal or the High Court or the Supreme Court, House of Lords, if it's an older case. And that will be an extract. It might be a little bit amended, it might be edited, but we'd be testing quite similar skills, but just in a different context. So can you identify relevant from irrelevant? Do you understand comprehension skills? Do you understand what this is about? Why it seems to be important? What aspects of the text seem to be more significant than others? Are there particular legal tests or definitions? Is there an argument being made for a particular view in this passage? And if so, what reasons are given in support? Can you identify counter arguments and why, let's say, the judge, if we're looking at an extract from a case, why the judge found that counter argument unconvincing, what reasons were given to reject it? Do you agree with the reasons given? Do you find the argument compelling? Do you think something's been missed, or do you think the reasoning is in some way kind of disconnected from the claim that's been made? Like it doesn't quite support the point, that the evidence given or the arguments given doesn't quite support the point. So I think, reflecting critically when you've got a sort of longer piece like that, which seems argumentative, whether it's from a case or maybe it's from an article, maybe a legal article, a legal academic article, or it could be from a newspaper or something like that. An argumentative piece. Do you agree with the argument? Candidates certainly should be thinking much more critically about that from the get-go. And I would expect those kinds of questions. What do you think we should be doing here? Why do you think this is a good argument or a bad argument? To be more dominant in an interview of that sort, often, not always, but often.
So is that one much more, not to just kind of describe it in one short sentence, but a comprehension of a text?
Yeah, I mean, comprehension's important in both because you can't figure out how a statute should be applied to facts if you don't understand, if you aren't able to really pay attention to the detail of how that language fits together to create an effect. But again, I think it's a different kind of comprehension challenge. When we set an extract from a case or an extract from a newspaper article or a journal, an academic journal article or something like that, often candidates are facing a wall of text that can be quite intimidating, and it will be complicated. The language will be complicated. It will be unfamiliar. It will be challenging. To rise to the challenge, you've got to sort of breathe, compose yourself, embrace the challenge. Ring words that you're uncertain about, but try and draw inferences about the meaning of those words from the surrounding context. Well, I don't know for sure, but based on the way in which this word is situated within the paragraph, my best guess is it probably means something a bit like this. And then you can ask for clarification. You can explore that uncertainty with the interviewers, and if it becomes relevant in the discussion.
Am I right in thinking that in the first interview, when you're trying to see if the piece of law applies, that kind of exercise, there's an element of problem solving alongside the comprehension critical analysis, but in the second interview there's less of an element of problem solving?
Sometimes it can be that way, but another way in which law is made and developed in this jurisdiction, a common law jurisdiction we call it, is through appellate decisions. So if the Court of Appeal when the Court of Appeal decides a point of law, that decision becomes authoritative. The judgment, if you like, becomes law.
Yeah.
And so sometimes this element of problem solving can feature in these interviews too. It depends a little bit on, what the nature of the extract is and what the nature of the questions that we ask might be. But I think across the two interviews, we're testing similar skills in different ways. Do you have a close attention to detail? Can you identify the claims that are being made in a piece of text, reasons in support of that claim? Can you apply tests to facts? Can you draw distinctions by identifying relevant differences? Can you see where cases are analogous, to go back to that word I defined earlier, where cases are so similar they should be treated in the same way? Can you identify, is this a strong argument or is it a weak argument, and why? Can you take on new information, synthesize it, work with it, see why you might need to adjust your view because of that new information and the significance of that new information? Or can you see where actually that new information doesn't change my view and shouldn't, and explain why? And those skills can be tested across the interviews. And as I say, we haven't always set interviews with pre-reading, but even in the interviews where we haven't set pre-reading, there's still been some kind of exercise involved. It might be, here's a kind of legal problem we might face. Can you give me a definition of this concept which might help us solve this problem?
I think it's more of a revealing of like my thinking beforehand, because I think I'd always seen like the sciences as like a problem solving area, and the humanities as like a critical analysis area where you kind of sit back and take apart the text, whereas it seems like in law they're consistent, they're both married together.
Yes, you get the best of both worlds, Siam, if you come and do law.
You never can like rest on your laurels and just be a critic, because you have to then see how it's applied, and you're also expected to know
exactly
how to solve the problems of what you've just suggested, I guess. Like you can never like just do one.
Yes, I think that's right. I mean, I certainly don't expect candidates in interview to solve the problems, but a desire to explore that in a structured, reasoned way. And the interview itself will provide that structure if you listen to us and answer the questions that we're asking, and not the questions you would rather we were asking. Because often people feel more comfortable in what I call the doctrinal analysis. Okay. So what I mean by that is, here are the rules that are provided in the law as it currently stands. Possibly those rules are sometimes ambiguous, and we've got to do a little bit of work to figure out how we think these ambiguous rules should be interpreted, and then we're applying them to the facts. Then there's the more critical, the sort of humanities side of the study, if you like. What should the law be? What principles and values ought to underpin the law, and how would we change the law to better reflect those values or to better achieve those ends? So what I see in students, certainly when they're on the course here at Cambridge, is some people are naturally more comfortable in one of those areas than the other. But one of the reasons why law is such a, I think, rigorous degree, but also such a fantastic preparation for all kinds of professional lives thereafter, is you've got to get good at both. You've got to do both. You can't really engage critically with what the law should be if you've got no idea what it is. And just understanding what the law is, I mean, I don't want to say it's boring. It's not. I think it's fascinating. I love the kind of black letter problem solving type stuff that we do. But there's so much more to the study of law than just that. And some of the really big questions that we explore, both on the course and sometimes at interview, is sort of what makes this really special, I think, and particularly what makes it special to study law at Cambridge.
Yeah, and the skills will make you highly employable for like almost any career, not just with being a lawyer. You'd be showing that you can both digest large amounts of text, but also problem solve.
Yeah, absolutely.
So with these exercises and interviews, do you have any tips for like upcoming applicants of how they can like prepare for them if they can?
Yeah, absolutely. I think there's a couple of, let's divide it into two, because I think there are tips I can give when you are actually in the interview itself, which are more specific and tailored and concerned with managing those exercises beyond the sort of general points I was saying earlier. And then there's sort of how do you prepare with those exercises in mind. So a couple of very basic tips for handling the exercise side of things in the interviews. Read them really carefully. Take notes. People like to read and take notes in different ways. Some people like to, print things off and do it all by hand. Some people are very comfortable, taking notes on a document on their computer, but have a sense of which you prefer and make sure that your interview is taking place in an environment where you're able, if you need to be able to print it off, make sure that you've talked to your school or you've got access to a printer, so you can do that. If you don't have access to a printer, you can't get access to a printer, maybe practice taking notes on a document on your computer so that the interview isn't the first time in which you've ever done that. So read them carefully, take notes, and then have that visible during the interview. It's not a memory test, right? We want students to be referring back to that material during the discussion. And it's not at all a problem for students to say, oh, can I just go back and look at let me just take a look, and then sort of physically look at the document. Or, often we know that we've got students flicking between windows when they're on Zoom, and that's fine because we want them to be reading that extract that we've sent to them. And that's really important because language matters. We were talking about attention to detail earlier in the sort of comprehension sort of skills that are on display. Sometimes when I have read something and I paraphrase it, it can be very easy to subtly change the meaning of the test, the provision, as I would say in legal terms, just by changing some of the words in which I use to summarize that point. And it's very important that we try and avoid that as lawyers. And so it's a skill that we're looking for in our law candidates, that they're able to very precisely and accurately identify. I think I just hit the microphone. Right. That they're able to very precisely and accurately identify those legal tests. And if you're not looking at the material enough, I mean, you don't want to be like this through the whole interview, right? Yeah. But if you're not referring back carefully, you might miss what we call a gloss that you've put on the language, so a way that you subtly changed the meaning of the language. So feel free, if you're unsure, to refer back to the material, so you can make sure that you have remembered that sentence or that form of words, that phrase, if it's really important to get it precise, that it is sort of we're working on the kind of the basis of the text as it's written, not the text as we've half remembered it to be. So read, take notes, have that in front of you. And then, when you're doing that reading, I mean, bearing in mind all of the sort of skills that I've said that we're testing, as you're going through, and, what do you highlight? What do you pick out? Are there any tests? What are the component parts of that test? Do you have components within that test, all of which are necessary, or only some of them necessary? Are there alternative ways of satisfying this test? Are there reasons given? What argument is being made? What claims are being made? statements about what the law is or what the law should be, are reasons given, are identifying the counter arguments, and just sort of flagging what these moving parts are, so that you can more quickly find the right part of the extract to help you support the answers you want to give to your interviewer in discussion. So that's sort of like in the room.
During
in
the
your
interview.
room, wherever you're interviewing during the interview. I think some tips for managing that. What was your other question?
So that would be tips for during the interview, but for students who are like leading up to the interview, how can they prepare? So
how to prepare
the weeks beforehand, or months beforehand.
I think some people find it difficult to have a mock interview. Maybe there's no one in their life or at their school who's able to give them a mock interview. No, they don't know anyone who's ever had a Cambridge interview before, and there can sometimes be a fear that like this is going to be really detrimental. I don't think that's the case at all. I had a mock interview before my interview at another place, and it was nothing like the interviews that I had when I was a student there. So I think it's I wouldn't worry too much about that, because there are some really helpful things that you can do. Read a lot, and read challenging material. I mean, look, don't get me wrong. I love a sort of easy read novel, at the end of a tough week. But it's good to have something that just like washes over you. But that's not very good interview prep, right? You've got to read things that you find difficult to understand, and grapple with it, and really try and focus and make some headway there, because that will help you develop the kind of comprehension skills. So, non-fiction books, good quality journalism, if you can find any. There's lots of good quality journalism out there, actually. You just need to, look in the right places. So good quality journalism, non-fiction books, material that you need to think about. Now, you don't have to read loads and loads and loads and loads and loads of it. What matters is what you do with the stuff that you're reading, because being a passive reader of this kind of information isn't going to be good interview prep, right? Take a small, take an article or a chapter or a section of a chapter, and imagine this might be something you're given an interview, right? What might your interviewers ask about it? What's this chapter about? Or what's this passage about? What's this article about? What argument is being made? What reasons are given in support of that claim? What kind of evidence is being used to support the argument? Do you think the argument is persuasive? Why not? If it's on a political topic or something like this, what should we be trying to achieve in this particular area? Why do we tax people, and what is the purpose of inheritance tax? And what are the sort of issues that we're facing and trying to cure with this budget, and is this a good way of solving the problem, for example, right? There's all sorts of material you can read, which is really helpful in that regard. And it's great if you've got someone else to talk to about it, but you don't need that. Some time. Write notes, test yourself. Have another go. And the more you practice this, the more being faced with, or the less likely it is you will be thrown by a piece of challenging text on a subject you've never considered before. If the first time you've ever really had to think about how, what is this argument? What are the reasons given in favor of it? What do I think of it? On a topic you just like, what even is that? If the first time you've ever had to do that is in an interview, then it's going to be more challenging than if you've had a bit of practice on that. But you can do that on your own with an internet connection or the school library.
And the notes app, just to type away.
Exactly. Exactly. So that, some breathing exercises if you are the kind of person who experiences nerves and anxiety, that's absolutely no barrier to success, either in the interview, in the applications process, or as a student here. What's going to help you? Some breathing exercises, that kind of mindfulness practice, and building it in regularly, so that you're sort of increasing your resilience to stress in the run up to what is inevitably going to be a challenging, sort of stressful process, is possibly a good idea for everyone. So testing the setup, if the first time you've ever been on a Zoom call is in an interview, that's going to increase the stressfulness of the situation. So, just get a friend to, or, a classmate or someone to give you a Zoom call. And then there are books you can read, like Letters to a Law Student, What About Law? We've got the University of Cambridge has an Exploring Law course that was set up by some colleagues in the law faculty, and I worked on the criminal law module. Professor Stephen Watterson, who's one of the directors of studies here, was leading on sort of forming that, putting that course together. And so there's a strong Trinity Hall presence in the Exploring Law course, but I think that's quite good preparation for sort of thinking about law. Students probably will be encouraged to read these books when they're thinking about how to apply to law, but there'll also be information in those books about, or in those resources about the kinds of skills that are helpful both as a student and as a candidate in the applications process, and are themselves quite good ways of honing those skills. I did a lot of Sudoku when I was applying for law.
Oh, really?
Yeah, I did. Yeah. I taught myself how to do Sudoku because it's just logical reasoning. Right?
Yeah.
It's problem solving.
Oh wow, that it helped you.
Yeah, exactly. Just trying to think critically.
Yeah.
Any ways of improving your critical thinking, I think, is really helpful.
Yeah, I mean, I think you want to be in a position where you can recognize and feel that critical thinking in any aspect is transferable. And I think once you kind of get that and feel that, then it will help you for your law interview.
Exactly. It'll help you for the rest of your life.
Yeah, exactly. Whereas I think it's if you're in a position where you've compartmentalized these things as separate to each other, then you want to realize that critical thinking, like in learning how to play Sudoku and getting good at that, that kind of problem solving will help in other aspects, like your law interview.
I think that's right. When I was a teenager, you wouldn't know now you wouldn't guess it now, I'm sure. But I was a football referee. I used to referee football. Oh,
really?
Yeah.
Nice.
And I think it was great preparation for a law degree, because all it is rule application, right? Like, that definitely is offside, and I'll tell you why. And I appreciate you don't think it is, but that's irrelevant. See you later. Crack on.
So when they shout at the ref, nothing changed?
Nothing changes. Yeah. Never let them see the whites of your eyes.
Oh, that's great. That's amazing how that is just entirely
totally transferable.
Yeah, exactly. Yeah. Amazing. So another question that we had is something that we have touched on already, is how similar are law interviews to the teaching in Cambridge? So like the supervisions.
Yeah, they're very similar. At least that's my intention. My goal, really, when I'm designing an interview exercise, is to try and strip back the structure, shape, feel of a supervision. So no pre-reading is, you don't need to do like, you don't have to have gone to 4 hours of lectures and read a textbook chapter and a bunch of cases. I can give you, 20 minutes, half an hour of reading, couple of pages, or a mock statute or something like this. But the discussion that we have structurally is very similar, because students come into the supervision and they have some understanding of what the law is, but that understanding is likely to be, incomplete, or there's going to be areas of confusion and uncertainty. And we will develop our understanding of what the law is. And then we'll often move on to thinking about, well, should it be like that? Why? Why not? What do we make of this? And what are we getting wrong? What could we be doing differently? And substantively, that's very, very similar to the kinds of discussions that we'll be having with candidates in interviews often. I'd be very surprised if a candidate isn't having at least one interview which feels a lot like, that. The difference, of course, is in a supervision. If a student says, "Oh, I'm not really sure, how this provision works," I will often say, "Well, it's a bit like it's like this," and let's go beyond that. So in a supervision, students get a lot more from us than candidates will, but for obvious reasons. I think we can't be in the business of telling people what the law is in the interviews if that's if that's like the part of the assessment that we're trying to undertake. But I've had students say to me, matriculation dinner, where sort of is like an event that students in their first week in Cambridge go to, and we all sit in the hall and have dinner together, and it's a lovely event. And inevitably, we often end up talking about interviews, and at that stage, there's I suppose a sense of how reflective is this going to be, like that people have very strong memories but have no idea like what their study is going to be like, and then by the sort of dinners that we have later on in the year, or the events that we have later on in the year, I talk to those students again and they go, oh yeah, actually supervisions felt quite a lot like the interview. Yeah. But what they usually end on is, but a bit less scary.
Exactly.
I mean, I try very hard to make sure that the interviews are scary, but there's only so much I can do.
I guess the other difference between supervisions and interviews is that in a supervision, the student would have been expected to do a lot more work than you are compared to the interview.
Yeah. I don't expect candidates coming into an interview to know anything about the law. I expect my students coming into supervisions to
have done the reading,
to have really done some reading and know quite a bit about the law by that point, actually. Yeah, because they work very hard.
And is law one of those subjects where for each supervision you hand in an essay?
No.
No. Okay.
So students do write a lot of essays. Law students do write a lot of essays, but the convention is that you'd write 4 or 5 essays per year for every paper that you sit, and that sort of works out as sort of every other supervision. On average, it may not, the pattern may not quite be alternating, but for about half of your supervisions you write essays. And we don't. Some colleagues, again, just like interviews, how supervisions actually work can be very varied. But it certainly, for myself, I don't structure the supervision discussion around the student's written work. Students will submit their essay usually before, sometimes after the supervision, but and I'll give feedback on that essay. But then the supervision discussion will not focus on the same essay question, may overlap in terms of the content, and sometimes students come out of the supervision and go, oh yeah, when you read that essay, I definitely didn't include that. And that, that's fine. That's okay.
It's quite funny.
Yeah.
Nice. So moving away from law interviews, there's an admissions test for law as well, the LNAT.
The Law National Admissions Test, yeah.
Oh, is that what it stands for?
Makes sense, right?
It does. Yeah, it does make sense. Can you provide us like a bit of information of like what the LNAT is, like, and what kind of like things it's testing for, and what kind of questions it has?
Absolutely. Look, there's lots of information out there about the LNAT, and anyone who's thinking of sitting it should certainly go on the LNAT website and read all of that information very carefully. But I suppose the headlines are, it's a test that you will sit online in a test centre. You need to book it. There is a cost associated with it, but there are bursaries available for students who will struggle to meet that cost. So you go, if anyone's ever sat with like the driving proficiency test, is that what it's called?
I think so.
I think so. I don't know. I actually can't drive, so I don't know. So you sort of go to a test centre like that.
Yeah, exactly.
And sit the test there. It's 2 hours and 15 minutes online. Also, it's not like on the internet, it's sort of on like its own like platform, but you take the test at the computer. The first section is a multiple choice question exercise. There are, I think, 42 questions over like 90-95 minutes, something in that region, and they give you passages of text. I think there are about 12 passages, passage of text, which you'll need to read, and then you have questions on that text, multiple choice. I think there are 4 or 5 options. There's a set number. I can't remember whether it's 4 or 5, but it will sort of ask you, and it will ask you really detailed questions about about that text. So it might be, which of these two concepts are compared to one another, which of the, or sort of put in opposition to one another. So it's, it's either this or it's that, or what reasons are given in support of this claim, or what claims are being made, what statements are made about this topic in this passage. Or it might be, it might ask you to think about, you might need to know what an inference is, or something like that, right? So the difference between statements which are explicit and statements which are implied. You might need to know the difference between a fact and an opinion. Now, these are basic elements of critical thinking, critical reasoning, and so they can all be sort of learned. And actually, a lot of this is covered in like GCSE English, right? So it isn't testing skills that students won't have if they're sort of generally doing well academically in their core subjects at GCSE and in their subjects at school. But the I would say it is important to practice the MCQ side of the LNAT. You can get free practice tests online. There are, outfits that will charge you quite a lot of money for, very rigorous. We'll definitely get, you can definitely pass the LNAT if you give us all this money. You don't need to do that. No. There are free tests available on the LNAT website, on other websites, and get as much practice in as you can. You can buy books where there's like banks of practice tests. You can buy these books online. But the great thing about books, as opposed to these sort of, really expensive, tutoring programs or whatever, is you can pick them up secondhand for really reasonable prices. And so I think that's probably a sensible thing for students to think about doing. But that's only the first half of the LNAT. Yeah. The second half of it is an essay. So you'll be presented with 3 questions. You choose one, you spend 40 minutes and you write an essay on it. And again, essay writing skills, this isn't, you don't have to sort of do anything particularly outlandish or unusual to prepare for the LNAT essay. Students applying to Cambridge for law should be, I would say, doing an essay-based subject at A-level anyway. A lot of our students take something like English or history, but not exclusively. People take law, government and politics. There are all sorts of A-levels in which students might write essays. I should say it's not a requirement. We have also taken students with, a full suite of maths and science A-levels, and they often make excellent law students because it's logical reasoning, problem solving, etc. But I would say if you are taking those kinds of A-levels, it's then even more important that you practice writing essays. If you're not doing an EPQ, if your school doesn't offer it, set yourself some essay questions and practice writing, because that does matter. So for the LNAT essay section, thinking about how do I write a short, concise argument in 40 minutes. You'd obviously be typing it. Be very clear about what your argument is in response to the question. Make sure you've got an introduction which signposts, as I always say to my students, signpost your argument. Tell me what the claim is. Yes, I think we should ban fox hunting. Something. I think that's actually what I wrote in my my LNAT essay. I always I either wrote this essay when I was doing A-levels or for the LNAT, because it's always like the non-law sort of, you don't need to know any law. There's no expectation in the LNAT essay that you know anything about the law. But you might have a sense of like whether or not freedom of speech should be absolute, or when it's ever appropriate to restrict freedom of speech. Whether we should, I don't know, like inheritance tax.
I think
again,
it also overlaps with what we were saying before about reading widely, but also not being not passively reading. But if you're reading quite a lot and you're being quite critical of what you're reading, and especially if you don't practice a lot of essay writing in your A-levels, you could just apply an essay question on what you read, and write an essay on on the stuff that you're reading.
Yeah, I think that's exactly it. That's excellent advice. You know, you take the journal, the newspaper article that you've read, what argument is being made, you turn that into the essay question, and then test yourself. Try and write the opposite view. If you've read a newspaper article or a piece which is argumentative in support of option A, just now set yourself the task in 40 minutes of writing an essay in favour of option B. I think would be an excellent way to practice. Certainly practicing writing concisely in a structured way, clearly, in under time pressure, I think is a good way to practice for the second section of the LNAT, because, you know, I don't know how long maybe I should ask my students how long they used to spend on their English literature or their history homework, you know, their essays. But I expect that a lot of that homework is done in much more leisurely settings than the LNAT.
I mean, some of the like best students I like were friends with would like time themselves, and it seems like I don't know, it seems like something that's quite far-fetched or like a extreme thing to do. Or you kind of think, oh, I can still achieve the same thing without it, but it could be a deal breaker.
And you know, one reads LNAT essays which are sort of, you know, someone's clearly ran out of time.
Exactly.
Now, if you're in that position, don't despair, because I've read LNAT essays where someone's clearly ran out of time, but
it was really good.
We give them a place, and it might be because what we see in what's being covered is you know, shows skill. The kind of skill that we're looking for, the kind of skill that we need, is possibly even still very impressive. And so it's still a good essay, even though someone's run out of time. Or it might just be that it's not the best part of their application, actually, but, you know, there's strengths elsewhere that, and it's a holistic assessment, right? Nothing's a deal breaker. So, you know, don't panic, but that kind of practice, that sort of discipline, is really good. And it's not artificial either, right? Nothing in the LNAT or the interview or the applications process in general is artificial, because the skills that you will practice in preparation for the LNAT and the skills that you will demonstrate in the LNAT are the skills that you will need to hit the ground running as a first-year law student here. And they are skills that you will continue to develop when you're on the course. Our students write a lot of essays. And if it takes you 3 days to write an essay, then you're not going to be able to keep up with the workload. So, you know, practicing how to write clearly and consistently quickly is important.
Nice. And to go back on this section, the first section, the multiple choice, I think we were talking about this beforehand, how really depending on, I guess, like what you've happened to read or covered, or what you're taught in school, can really, it makes a big difference, because you could be someone who sees it's a critical thinking assessment and just kind of know what that is, or this assessment might be your first time you've heard of the words critical thinking, even though you have really good critical thinking skills that you show in your subjects, you just don't specifically know what it means. So I was in that position when I was preparing for my assessment. And I think getting a cheap secondhand critical thinking book just and reading that over changed a lot and made me kind of like streamline my thinking, and then made the test a lot more straightforward. Because I think those kind of books, when they go through examples of like, these are the premises, what are the conclusions, etc., you kind of get into a habit of specifically what the test is asking.
It's a discipline, isn't it? And I think that's right. And that doesn't have to be an LNAT specific book. Any kind of book aimed at sixth form age students on the topic of critical thinking and developing critical thinking, critical reasoning skills is going to be helpful for the LNAT. But it's, like I was saying earlier, it's also going to be helpful for you as a lawyer, whether you come to Cambridge or anywhere else. You know, critical thinking is the bread and butter, critical reasoning is the bread and butter of legal study, and ultimately legal practice. So it's good to pick it up, and to pick it up early, because you want to be building practice in repeatedly over a longer period of time in the run up to the test, rather than trying to cram everything in a week. Because as you say, Siam, it's a way of thinking. And, you know, once you've done it, it's always in there, right?
Because I think, and it's definitely not something you can really cram, because it's really kind of reprogramming a little bit of how you view text. But
you'll never be the same again.
There's a lot of truth in that. I think there's a book called Thinking Skills. The teacher suggested to me. He did politics, really good guy. But I think there is a difference between, so you have two individuals, they're reading a piece of text, both probably like very good at analysing text, but one of them is very in touch with the discipline of critical thinking. They will view it from a different perspective. They can also view it from other perspectives. But the person who hasn't come across critical thinking will probably eventually achieve the same end, but probably in a very personal or unique way, because they haven't had any learning in that discipline.
I think what it allows you to do is sort of strip an argument back to its moving parts.
Exactly.
And once you can see the way the kind of cogs and wheels work together, it's easier to spot weaknesses or gaps in arguments, or develop those arguments further in a way which is consistent with what was given. Now, that aspect isn't something that's covered in the MCQ, the multiple choice questions for the LNAT, but it's very similar to what we do in interview, right? So there's a theme developing, right? The different component parts of the admissions sort of process holistically are sort of giving you different opportunities to demonstrate similar skills.
Yeah, exactly. Nice. Wow.
Do you want me to say a bit more about essay writing? I sort of talked a little bit about introductions, but it strikes me that sometimes I don't necessarily know what students are being told about what makes a good essay. So you'll be asked a question. It's really important that your analysis focuses on that specific question asked. If you deviate from that, don't answer the question you wish you'd been asked. Even if you've got a brilliant essay on this kind of similar but actually adjacent, just next to it, not the same thing, question, don't give us that answer, because no matter how good it is, you're not answering the specific question that you've been asked. And that's one of the first things that we're sort of, really keen to see. Clear response. Can I see from that first introductory paragraph what your argument is? Have you summarized the reasons that you're going to go on to describe in more detail or explain in more detail in support of that view? And then make sure every paragraph does a job, right? It's got to serve a purpose, and it's got to be really clear to me, ideally, why that paragraph is even there in the first place. How does it help you answer the argument? Give reasons in support of your argument. If you're aware of evidence, then draw on it. But the LNAT questions, I think, essay questions are often, you're not expected to have done pre-reading for that LNAT question, so they're designed in a way to be sort of quite open textured. I don't expect anyone to have empirical data to support their statistics or anything like that to support their reasoning. Why we wouldn't expect to see that, but you do need to have reason. So if you think that free speech shouldn't be absolute, why not? And can you kind of categorize those reasons so that there's some sense of order to the essay? There's a reason why paragraph 1 comes first, paragraph 2 comes next, paragraph 3 comes later, and then a conclusion that just summarizes your argument, reminds your reader of the strands of the argument, and kind of pulls it all together. You don't want it to be one-sided. The aim is to be persuasive, to persuade your reader that your view is the better view, but no persuasive argument ignores the other plausible views or approaches out there. So if there's an obvious counter-argument to the particular approach that you've taken, identify that counter-argument, articulate it. Don't set up what we call a straw man, like a really implausible, weak, watered-down version of this counter-argument, which then becomes really easy to just brush aside. Give a credible articulation of that counter-argument, and then explain why you think it's not persuasive, it misses something, it doesn't it doesn't appropriately prioritize or value some other important concern, and make sure you've integrated a counter argument somewhere along the way.
Nice. Yeah, I mean, I guess, yeah, like even in a normal conversation, if you see someone's deliberately ignoring a counter example, it's not as convincing if they were to address it.
Exactly.
But then still explain how their argument makes sense whilst addressing those counter examples.
Exactly.
I think when we're talking about practicing essay writing with, say, you're reading a newspaper article, you've written an essay, there's no reason why you can't 2 days later read back what you've written and see, like, with a new fresh set of eyes, how credible is this essay, like, what things would you do differently, and what ways could it be improved better. Those things will help.
I think that's right. And look, it's unusual, I think, for students in their school to be the only person applying for law. So if you do have friends or maybe people classmates who are applying for law, why don't you all get together and do this? You can all take an essay question, write an essay on that topic, and then circulate those essays and sort of peer mark or kind of try and you take one side, I'll take another, and we'll see where we come to. And working together in that way can be quite helpful. Yeah,
I think that's really good advice. We did the same. We all did like the same past paper and then came together and talked through our answers, which really helped. Which also helped the oral side of the interview.
Exactly, and you don't really want an interview to be the first time you've ever made an argument out loud. So working together can help.
Nice.
Can really help.
So lastly that we have here is just to round off the application process. How in law do we give, like, who do we choose? How do we choose who to give offers to? And once we've got all of the students' information.
I think there are sometimes quite a lot of misconceptions around this. Like, if I have one bad interview, does that mean that I'll definitely not get a place? Or if I don't do so well on the LNAT, is it really just all about the LNAT? And I think the answer is, I'm sure anyone who's listened to more than one podcast about admissions or read information from more than one source is probably what they've heard before. We really do take a holistic view. I mean, look, if you do not so good a job, like really not so good a job on both parts of the LNAT, that's obviously not great in terms of the application, but you never look at just one piece of the puzzle on its own. You always look at across the whole range, and strength in one area will compensate for a lower performance on some other sort of aspect of the application. And we're testing similar skills. I think the most important skills that we're testing for are tested for across different aspects of the application. So there's a reason why strength in one area compensates for weakness in the other, because everyone can have a bad day at the office, right? And we need to take account for that. So there's a degree of I suppose duplication in assessment. To account for that. So I think I want our applicants to bear that in mind, because I think that message, if it's received, can often be quite helpful in reducing some of the anxiety around the application process. Look, I'm not going to kind of go into the very boring ins and outs of how we kind of look at all that data and process it, because we spend a very lot of time doing that. But we look at every single application very carefully. Very, very careful decisions are made about, whether to call someone to interview or not. The majority of applicants who apply to us are called for interview. So, we do think about deselections very carefully. And then when we get to the stage of, making offers, after the process is completed, where we are very rigorous in the way that we go about doing that. Because it's very, very important to us that we get it right, because we're going to be spending a lot of time with our students. And I think it's important to know that in my view, if we don't make an applicant an offer, it's not because they're not clever. Even just to meet to have the predicted grades that meet the entry requirements, to get into a position where you're being called to interview at one of the most competitive and prestigious institutions for the undergraduate study of law in the world, never mind just in the UK, you have to have a, intelligence, potential, ability beyond doubt. But this is a very particular kind of environment in which to study. If the way in which we teach law is very different to almost all other institutions, and some very, very intelligent people aren't necessarily well suited to this kind of environment, or they might not necessarily be well suited to the study of law, and that's something that might become apparent in the process, and then sometimes candidates might decide, actually, I've gone through this process, I don't actually think I want to study law, I'm going to take a year, rethink and start again. Like, all of these decisions are good decisions. And also, we might just be in a situation where we've got, X number of students who are good enough, but we don't have enough places. And that might be true across the collegiate university. The pool system, which I'm sure you've got podcasts covering the pool in detail, but to reiterate the point, it is true that hopefully, I would hope that all deserving candidates we can find a place for, but that's not always going to be possible, because there's lots of really smart students out there. And at some point we just can't take any more. So I would never want an unsuccessful candidate to think that the decision not to offer them a place is a reflection on their ability or potential in life.
Which is very true.
There is ultimately there are only so many places we can offer.
Yeah, because it is true that logistically there aren't enough places in the university to provide offers to all those who are deserving of one. Yeah,
and I really can't say hand on heart that every student I've ever who's interviewed with me and gone through an admissions process with me, to whom we haven't offered a place, wouldn't have succeeded here. I'm sure that they would have done. But what I can say is that the students who we do offer places to, and who make their grades and who come, deserve to be here, because they've gone through a very rigorous, very serious process, and that gives us confidence and should give them confidence that they can succeed and indeed thrive when they're here at Cambridge. And I think that's one of the best things about our admission system, really, is that everyone has a chance to make sure that this is really going to be the right environment for the student.
Because I think that kind of imposter syndrome is so common with students. I remember I had a bit of it as well.
Oh yeah.
Same. And I remember thinking, I had it in two kind of ways. One way in that I thought everyone else's imposter syndrome was clearly flawed. But yours was real. Mine was real. Because I was actually an imposter. But then a bit later I realised that was also imposter syndrome. And then the other thing was that I remember thinking that I did really well in the interviews, my application was really strong, and kind of was in a position where I wasn't, I guess, performing as well as I thought I was at the start, and then thinking that I was an imposter because I was not that same person. But then I kind of realised that that's in the interview, at the end of the application, they're giving out offers. What the admissions officers and the DOSs, the directors of studies, what they're saying is that from what they've seen in the application, we believe in you, and we believe that you're deserving of an offer. So even if you're, whatever route you take, you're never an imposter because you've had that faith put into you.
Yeah, exactly. And it's I want our students to see it as a really genuine vote of confidence, and that confidence doesn't go. One of the great things about studying here, and I know my colleagues in there are going to sort of talk more about the law degree, is the support that you get as a student from your directors of studies, from your supervisors, from your pastoral tutors. There's a lot of help on that journey. But look, when we take a student and they come up at the start of the first year, if it was all going to be easy for them, then really, like, there's no point in me having a job, right?
Yeah.
Like, don't tell the bursar, because he'll just get rid of us all. If it was easy, what's the point? It's a sign that we know that you have the potential and the skills that you need to develop across a 3-year degree, and come out at the other end of it with a really fantastic and highly transferable set of skills. Cambridge lawyers make excellent lawyers, but they're excellent in a whole other range of areas too. And I think it's important that potential applicants to Trinity Hall know that we don't care whether you've got lawyers in the family, whether you've been able to do any work experience in law, because sometimes that can be difficult if you don't if you just don't have those opportunities for whatever reason. We make our offers irrespective of race, gender, religion, where you were born, where you come from. What we want to find are students with that potential and that ability, and it's important to us that students from backgrounds which are traditionally underrepresented at institutions like ours feel really strongly encouraged to apply here. And I'm sure there are podcasts on the way we take contextual information into account in the admissions process. As law fellows, we're really committed to that process and making sure that inclusivity is a real understanding of educational inequality is part of our process. That isn't to say that there are different standards we expect people to reach in a kind of substantive sort of sense. Everyone who gets a place here is I know, deserving of a place. And that process is really rigorous and really fair. And I think if anyone's worried about whether Trinity Hall Law is a place where they'll feel welcomed and included and where they'll fit in, then I really hope that they can get in touch with the admissions team, and if necessary, we can link up to help reassure them that they will find a place for them here at Trinity Hall.
Yeah, no, definitely do email if you have queries like that, for sure. And the last question that we have here is, so if an applicant was to be successful and they were to achieve their offer, so they know they're coming to Cambridge, and if they apply to Trinity Hall, they know they're coming to Trinity Hall. What ways can students prepare for their study of law, like before they arrive at Cambridge?
Good. Keep reading. They've probably done quite a lot of reading. If they've sort of prepared well throughout the application, they're probably readers. So keep reading. Read nonfiction. Keep reading things that are complicated. Read about law. There's loads of interesting stuff going on. You can watch the Post Office Horizon Inquiry. It's live streamed on YouTube, and when you've got this long summer with not much to do, there's some fascinating, excellent examples of advocacy and the law in practice you can go and look at. The Secret Barrister's books, if you're interested in criminal law, I think are a great read, and will give you an insight into some of the broader social challenges and the broader sort of political and economic context in which the criminal justice system operates, and that will be helpful to you when you come up and study criminal law in your first year. There's an exploring law course that the University of Cambridge runs. Some people might have done that sort of pre-application. That's really where it's aimed, but there's no harm in doing that over the summer, if before you come up, if you can. The law faculty has a pre-arrival course. So in terms of, okay, sure, but how do I hit the ground running in terms of supervisions, lectures, etc., knowing what I'm doing? There's a pre-arrival course that the faculty runs. That's very, very helpful. I think it's sort of relatively new. A lot of work's gone into making sure that it gives students a good grounding when the work really begins at the start of term. So there will be something that comes your way, which is structured and tailored to your needs. And, I think another reason why it's great to come and study law at Trinity Hall is, we get our first year students up a whole week early. Not every college does this. And we give our students a really carefully considered sort of induction week program.
Oh, nice.
Now that's not law related, that's a general program, but there is a strong academic component to that induction week program. Provided I'm not on sabbatical leave that particular term, but I'm usually one of the fellows who holds a session with students in the sort of arts, humanities, social sciences on sort of how to get the most out of supervisions. So before you have a supervision, you'll have a session, sort of a group session with me, which gives you a bit of information about how supervisions work and how to get the most out of them. So, the college does between the college and the faculty, there'll be some structure and guidance for how to prepare. But beyond that, keep reading, keep lighting a fire, keep that fire warm, your enthusiasm for law by finding things in the media that interest you, and books on shelves. And then the final thing I'd say is, maybe go to your local Crown Court. You don't have to get on an expensive train to come down to London from the northeast or Scotland or wherever to see the law in action. Get on the bus, go to your local Crown Court. Justice is public, right? Open justice. You're entitled as a member of the public to go and sit in the public gallery. Occasionally there can be contexts in which that's not appropriate and permitted, but the staff at the court will be able to help you with that and let them know, hey, I've got an offer to study law at Cambridge from October. Is there anything that you think would be interesting for me to go and see today, and go and watch a case. You might learn something, and if you're lucky, the usher might let the judge or one of the barristers in the case know that there's a future lawyer sitting in the back, and they might come and say hi and tell you what's been going on with the case. They might not. They're all very busy people, and look, the criminal justice system is creaking under chronic underfunding over a long period of time. So don't be surprised if you see very busy people rushing around, and a lot of delays and things being put back. And
it's also interesting to see that firsthand, though.
Yeah.
Because then it's not something that's just on the paper. You're actually seeing how the system is quite
very, very real, very real. And do be careful. I mean, I say go to the Crown Court, and it's great advice, and you really should. But do be mindful that it's probably worth knowing what kind of what you're walking into, because you might not want to sort of go and walk into the middle of a trial on something that's very distressing and upsetting. But sort of a theft or something like that might be quite interesting to see. Closing arguments in a theft case. Cross-examination of a witness who the prosecution thinks is being less than fully honest with the court. It's exciting times.
Exactly. Yeah. Nice. Wow, amazing. Well, thank you so much, Rachel, for such a interesting podcast on the admissions process, the interviews, the LNAT.
Thank you so much for having me. I really hope that for the audience watching, it's been helpful, and that it encourages people to make more informed decisions about whether this route is right for them, and if it is, to come to Trinity Hall.
Nice. Yeah, because I think there's so many people who are just wanting to apply for law, but they just have so many questions, and there's just not enough content. Especially discursive content. So I'm happy that we've covered all these bases.
Great.
Nice.
Fab.
Cool. Was that everything?
Yeah, that's all good for me. Yeah. Nice. Amazing. Oh right, I'm gonna go shovel food in my face.